Spaghettello, simply marvellous pianist. I often think that had I not chosen the law, I should have become a pianist myself. I'm an accomplished tinkler of the ivories, you know. Anyway, I want to talk to you today at A-level law students about the doctrine of precedent. If you say, look here, Binkham, what in simple terms is this bloomin' doctrine of precedent all about? This is what I would say. Judges create legal rules in the course of deciding cases. Judges make laws as cases are brought before them. A judge cannot just wake up one day and decide to change the law. The judge has to wait for an appropriate case with the right sort of facts to come before him or her. Even then, the doctrine of precedent says that a judge should normally follow the legal rules created by judges in earlier cases. These earlier cases, containing legal rules, are known as precedents. In this video, I will briefly explain these key terms from the doctrine of precedent. Ratio decidendi, obiter dicta, distinguishing, reversing, and persuasive precedent. Law students, if you can get the hang of all this, you will find it very useful indeed when you are studying different areas of law, such as criminal law, negligence, or contract. Let me draw a comparison between the doctrine of precedent and normal family life. Suppose Jane, a 10-year-old child, walks around the sitting room in her muddy little shoes, leaving muddy marks all across the new carpet. What does the anguished parent do? She creates a rule in relation to wearing shoes. Jane is prohibited from viewing the old televisual entertainment, the TV, if she leaves shoes on in the house. That is the rule. In legal terms, you might call it a precedent. On any other occasion where shoes are not taken off, the precedent should be applied. Judges, a bit like mothers, are expected to be consistent. Judges need to treat each case the same. In all fairness, judges should use the same principle in similar cases. So, if mud is brought into the house, the TV is turned off where the shoes, football boots, or Wellington boots are to blame. Fair enough, really. It's the little people not taking the footwear off that is the problem. This is more or less how it works with common law judges. The common law, by the way, is judge-made law. One complication is that whereas we only have one set of parents, our society has many judges and several types of court. Some judges in the higher courts, the appeal courts, get to change the rules because the view they take of what the law should be can override what a judge has previously decided in the lower courts. A-level law students study and learn the hierarchy of the courts and which court must follow the precedents of which court. But judges look back at what precedents, common law rules, were applied by judges in similar cases. They may apply those precedents, or they may feel that the law needs to change for some reason, so they deviate from the existing precedents. You see, a judge has to explain their legal reasoning in a written judgment. Later judges read earlier judgments from precedents with facts similar to the case before them. A judgment contains, among other things, a ratio decidendi and an obiter dicta. Well, there may be many obiter dicta. The ratio decidendi, ratio for short, is the central rule stemming from the judgment. It's needed to decide the case. This ratio is the part of the judgment that becomes a precedent, i.e., other judges have to apply it. It binds them. Any of the cases that you will find in a law book have a ratio. If you want to find an example of a famous and interesting case with a ratio that has affected many later cases, see what you can find out on the internet about Donoghue and Stevenson. In our muddy shoes analogy, the ratio, the central rule is muddy footwear must be taken off at the door. In Donahue and Stevenson, the ratio is generally regarded to be something like manufacturers owe a duty of care to all those who might be expected to consume their products. This is the central rule that made Donahue and Stevenson an important precedent for modern judges. Obiter dicta are other comments about the law made in a judgment, relevant to the judge's explanation of his decision, but not strictly required to decide the case. Obiter dicta could be explained like this. Suppose the mother said, at the time of the muddy shoes, "And if you throw the dog's ball in the garden, you will not get your pocket money." Poor Jane is thinking, But I haven't touched the dog's ball. Nevertheless, if the dog's ball is thrown in the garden next week, you might guess what Mum will remember saying. You could say she will look at obiter dicta from the case of the muddy shoes. One example, among many of course, of obiter dicta is Home Office and Dorset Yacht Company, 1970. In this case, a judgment included a lengthy discussion about the duty of care, mentioned in Donahue, that was really not needed to decide the case on its facts, so was not strictly speaking binding, but had a great influence on the thinking of judges in later cases. What if a judge feels that another judge got it wrong in a precedent? The law may be seen as unfair or just not very practical, for example. Problematic precedents may be avoided rather than followed through the use of distinguishing, overruling, or reversing. Now, distinguishing is about a judge showing how, despite appearances, the facts of a case differ significantly from those in a precedent. Distinguishing involves making a decision about what are significant factual differences between cases. Let's go back to our simple muddy shoes scenario. Suppose toddler Tim, younger brother of our earlier offender, also hops about in welly boots in the hallway. Your badly done to school-aged child tells Judge Mum and demands that toddler Tim loses TV time as well. Only fair? Well, Mum might decide that she could distinguish this case on the basis that even though shoes were worn indoors, the toddler should not be punished as he's too young to understand the rule. Overruling is something different. Overruling may occur when a court is asked to review whether a precedent created in an earlier case by a lower court is correct law. For example, in McLaughlin and O'Brien, an appeal court in 1982 looked at a case from a lower court, in the judgment in Delu and White and Sons, which seemed to involve similar facts, but it overruled that 1901 precedent, deciding that the law should change. Reversing occurs when a higher court changes the decision of a lower court on exactly the same facts. In other words, an appeal judge in a specific case reverses the decision of the original trial judge. Persuasive precedent. Persuasive precedents are ones that judges do not technically bind later judges, but nevertheless influence their thinking. Because the courts tend to be anxious about the law being certain, they may follow an established ruling even though they are not strictly required to. For example, Court of Appeal judges might follow the approach used in a number of persuasive High Court rulings. Another example of persuasive precedent is a case from an appeal court from a legal system outside but similar to the UK system. For example, judges may consider rules stemming from Canadian, Australian, and even US cases. These cases are not binding precedents for UK judges, but do influence their thinking. So, to sum up, the doctrine of precedent says that a judge should normally follow the legal rules created by judges in earlier cases. A judgment contains, among other things, a ratio decidendi and obiter dicta. Precedents may be avoided, rather than followed, through the use of distinguishing, overruling, or reversing. Finally, persuasive precedents influence the thinking of judges, but do not bind them. To find out more, you may care to visit learnloads.com. Goodbye.